Yeah, thank you for the introduction. Also, I will just dive right into the topic, the unreliable human mind. And as you have heard already, I'm a psychologist, so I'm coming from the empirical area, and I will present you some of my research in this area. So legal decisions are at least in part based on human memory. And as you will see, I'm mainly coming, so if I'm touching legal areas, it's mostly criminal law, I guess, but maybe some other areas, or maybe some of the research is important for other areas as well. And at least like in criminal law, we know, I mean, there's eyewitness testimony, so where we rely on human memory, or sometimes, for instance, eyewitness identification, where we rely on that the person identifies the right target as a suspect. But of course, not only the eyewitnesses and like experts and so on are humans, but the decision makers are as well. And what we know also is, like for instance, in the German system or in the, for instance, US American system in a jury. And we know a lot by now already. So I'm not claiming at all that like I'm the only or the first one doing research into these in these areas, but maybe I can add some of the research to these areas. We know that memory is fallible, and malleable. There's really a lot of research. The one cited here is just reviews and meta-analyses covering some of them. And we also know that the decisions that are made by humans are very often biased by a lot of very different things. And as I said, there's a lot of research on this. I'm going to present you just 3 areas of my research that speak to those questions or issues. And I'm going to start with false memories in potential eyewitnesses. And then I'm going to present 2 studies on decision-making, which is one about hindsight bias in judges in criminal law cases. And this, the other study I'm going to present is not published yet. It's like fresh pressed data and results about the effect of criminal pre-trial publicity on actual sentences in also criminal cases on first-degree murder. Okay, so let me dive into it, and then I think we'll have a lot of time in the end for questions and discussion. Let me start with false memories. So being on the eyewitness part here. We know that memories are reconstructions, not reproductions. So there are quite some people who believe that memory works like a tape recorder, so that records like everything and you can rewind and whatever, but it doesn't. Just to give you an example, if I ask you like what you did on October 1st last year, you probably experienced, if you did not get married that day, or if you did not like, had your whatever birthday or did something really special, you probably, so you experience, you cannot rewind, but you think like, okay, what day was that? And then you might know, okay, October 3rd is like a holiday. What did I do there? So 2 days back, do I still know? I don't know. So what you can see here is already that it's a reconstruction. So it's not a passive retrieval of memories, but it's an active reconstruction. You kind of try to make sense of whatever you did on that day. You try to reconstruct to get close to whatever you did on that day. So you cannot rewind. And much research has documented that within this process of reconstructing your memories, there are quite a lot of memory errors, just by chance associated things you associate with the event which did not take place, for instance. We know that questions, for instance, really impact the answers. For instance, there has been a seminal study by Loftus and Palmer where they asked eyewitnesses of a car accident, like how fast the cars were going when and what they just varied was the verb that followed, like hit or smashed or bumped or touched or contacted. And the speed estimations varied accordingly with those verbs. So as you can see, questions can shape the answers, for instance. We also know from a lot of research that there's influence of misinformation. So for instance, consider a case where an eyewitness later reads a media report or talks to other witnesses later on, where there's other information that the person then encodes and kind of later believes that she has herself witnessed that detail, whereas in fact she got it from another source, for instance. That's the misinformation effect. But in its most extreme case, and we know this is possible because some research has shown it already, it's even possible to suggest entire events to people that never happened. And it's astonishingly easy to do so. We did that. I will present you a study on it in a moment, but let me just briefly mention that why we did that was basically we wanted to try to reverse those false memories. Suggesting false memories of entire events has been documented before, so that's not like that's not the novel part here. But we wanted to see whether we can reverse those false memories after the fact. What we did, and the study was IRB approved, in case you wonder. What we did is we recruited participants, adult participants, the usual suspects of participants, sorry. So basically students from a university, non-psychology students, because we were kind of afraid that they might, look through the deception. And we first contacted their parents. So we really made contact with the parents. We also told them what we are about to do. So we really told them we want to implant false memories and we want to try to reverse those. That's the issue. If you don't want to partake, that's totally fine. But then, okay, your child cannot either, but not to put pressure on it, but just to be clear about it. So the parents knew about what we wanted to do. And they were, of course, told to not talk with the participants, so their children, about it within the time frame of the study. We asked parents in a parent questionnaire about several events, whether they have taken place or not, within a time frame, an age frame of like 4 to 14. So in the childhood of their children. That's just part of it. And basically to come up with events that did take place. So true events, which I will call later on. So basically they were asked to describe, and it was always a negative event, but not traumatic event. That's ethically, of course, not responsible. So, but we wanted to try to get at least into the negative valence, because that's important for the legal context. And for false events, we asked participants to come up with events that really, really did not happen to their children in that time frame, but which could have been plausible, like really plausible. Because prior studies have sometimes just, taken one event and tried to suggest it to all people, something like the death of your pet. But people who never had a pet, well, they will never be able to really, develop a false memory about that. So that's not plausible, and they just reject it, and then you're gone. So we came up with, per participants, with 4 events. 2 true events, which actually had taken place, and 2 false events, which did not have taken place according to parents, which we tried to suggest within 3 suggestive interviews, which were taking place 2 weeks apart, so each 1 week apart. And we also had different suggestion conditions. The minimal suggestion condition sounds so minimal, but actually I think it's like the most important suggestion is we sat there, or basically one interviewer we had who was blind to the condition of the event, sat there and said something like, okay, your parents told me that you got lost in the vacation in Italy when you were 12. What can you tell me about it? And basically, I think that's the most part of the suggestion. Sitting there saying, claiming, this has taken place. What can you tell me? And for events that did not take place, people usually think like, interesting, I don't really have a memory about that, but let me see. So, and then they come try to construct a story how it could have been. So they make some plausible speculations about it, for instance. And later on, they think that those speculations and the images they have developed in this suggestive interview are actual memories they had just forgotten, or, pushed away or whatever. In the massive suggestion condition, it was really only that we gave them more time. We tried to encourage them more to be, well done, to do some kind of context reinstatement, try to really reinstate, like, how was it in that vacation? Can you try to place yourself in that context? What can you still remember something? And then after this third interview, so there were only like 3 sessions, and within this third session, we did 2 countermeasures in order to try to reverse those false memories. Namely, one was called source sensitization, where we made people aware of the fact that our memories are often a mixture from different sources. For instance, you might remember things from your childhood that actually come from like photographs or stories that are told within your family, for instance. So you remember the story or you remember the photograph, but you don't actually really remember experiencing that event yourself. And we asked participants to really just stick to what they remember themselves, what they have experienced. So not to report on other sources. And the second one was that we just really made people aware of the fact that when asking for childhood events, it's always possible to elicit false memories. There's some kind of danger of it. It could be, doesn't have to be the case. So we didn't want to suggest false memories here, but we want to make people aware of this possibility. And we just asked them to tell us if that was the case, if they had the feeling that that was the case here. We then transcribed and coded participants' memory reports, and we had like 6 categories: rejecting the event, saying like, really, no, sorry, this must be a mistake. My parents must be mistaken. That's really not true. Saying no memory, I really can't remember anything. Accepting the event in terms of, yeah, I guess this has happened. I would trust my parents, but I really have no memory. And then just different forms of false memories in case of false events, which means that people had to come up with some detail we did not tell them, right? So that was like the minimum criterion for false memory, and this means just there were more of those details they told us. Maybe. Yeah, let me just briefly tell you this, but I think the next slide maybe actually easier to grasp. So what we have here in green are the true events, and you can see there's not so much going on, and they are all like on average in the memory area, right? So on average, people remember those events. Here you can see quite some change. There's an increase going at least on average to partial memory, and then going back over the countermeasures. But maybe it's more informative to look at the false memories only. So this is only the condition of those we try to suggest. And what you can see here is that, let's take just this example. So the massive suggestion condition in the third interview, so after our suggestion period, there were like 56 participants who had developed a false memory. So more than half of our participants. As you can see here, the percentage is smaller, but like under the, let's say, best conditions for false memories, it's more than half. And it's just really adults who are not at all in some way pathologic or whatever. So just normal students. So basically, I think this documents 2 types of influence on human memory, right? On the one hand, we have the development of memories for events that never happened. Research has shown that before, but we just kind of corroborated it again and showed it in a proportion that has never been shown before. But also what we were able to show is an influence that we could convince people later on, at least some of them, that these memories are false. And again, human memory doesn't work as a recorder, so they can't delete them, right? It's not, they just delete them, but they rather understand that the details and the pictures they have in their head were constructed in their head, in their head, and that they did not really experience that, but that it's just rather a false memory. And this is after only like 3 suggestive interviews. So of course, it's a highly suggestive situation, but I mean, it's because it's usually credible researchers being in a credible institution like university. So that's a big part of social influence taking place, right? So authority, expertise, reputation. So nevertheless, it's quite a similar situation in like interrogations or, for instance, the therapeutic context, where particularly vulnerable people come to, for instance, search for explanations for some suffering, and they might be convinced that they might have repressed something, and they sit in front of an expert and an authority person who might tell them, yeah, I think so too, we shall look for that. And they might search for something that never existed. And by the way, I think I'm going to mention it later, but there's no evidence for repression, no evidence, and there's a lot of counter evidence. So that's really like the best precondition for false memories. So it's not the only context, but there's also in the real world, so not only in the lab, but also in the real world, we have such suggestive contexts. And of course, it was negative events, not traumatic events. And very often in criminal law, it's about things we could call traumatic events. So one criticism is very often, yeah, okay, but you just show it for really mild negative events. But of course, and this has to be the case because it's just we're ethically bound here, and that's for a good reason. But this research from the lab is really well complemented by field reports and field studies about retractors, who are people who say that in their life, they previously had no memory of some kind of child abuse or whatever, then usually went into some kind of therapy or consulting or whatever, developed a memory of this childhood trauma, and later on are convinced that this was a false memory that was suggested to them, or which they suggested themselves to themselves, or whatever. So they kind of retract this memory. Of course, we don't know the ground truth here, and that's a really difficult thing. But if you look into the research, the social influence processes are the very same processes we have in the lab. So it's really likely to speak about false memories here. Also, I don't know whether you have heard about the recent debate, at least in some circles, it's a really hot topic right now. It's a debate about ritual sexual abuse with mind control. And we have recently argued that there's really not good reason for taking that as actual evidence, because the reports of those self-defined affected persons ignore really well-established phenomena like childhood amnesia, the fact that you do not remember your first years of your life. And they're based on the myth of repressed memory, for which there is, as I said, no evidence, but a lot of counter evidence. And actually, false memories are a more plausible alternative explanation for this very narrow aspect of ritual sexual abuse with mind control, not speaking about sexual abuse in general, of course. And yeah, so it's I would say there's a lot of research out there that really complements our findings and others' findings, clearly establishing that it's possible also to suggest traumatic events, even of like really years-long sexual abuse by really close people, as in the case of ritual sexual abuse. Okay, why it might be difficult to really realize that it might be false memories is that they are really very similar to true memories. In a recent scoping review from a doctoral student of mine, we kind of summarized the studies so far, and we found robust differences only for 6 out of 131 variables. That means they were significant and they were replicated, but even those 6 variables are not suitable for distinguishing true and false memories in the individual case, because as you can see, there's quite a lot of overlap. For instance, for self-evaluated confidence, so how confident are you yourself that this is a true actual memory? You see a lot of overlap. It's really difficult for a single case to derive some kind of conclusion there. Similar for other variables, and as I said, it's only for 6 that we found at all some significant effects. So it's rather easy to implant false memories. Maybe, astonishingly easy, but it's rather difficult, or even if possible, to identify those false memories, which makes it even a more difficult issue. Again, it's after a rather short period of suggestion. Also, like the differences between the true and false memories, that was all research from the lab. And the lab usually, so lab studies on false memories usually are similar to the ones we did. So basically you have something like 3 sessions, each 1 week apart. And so it's just like 3 interviews in 2 weeks. In the field, we are often talking about years of therapy. And sometimes something like, and yeah, of course, the longer the suggestion period, so in case their suggestion takes place in therapy, the more likely you would expect that the false memories resulting from it have really high quality and are even less distinguishable from true memories, right? So there are maybe not even any differences anymore. And of course, likely, the more difficult to reverse them. I'm sorry. I think, I took the wrong button. The more difficult to reverse them. And that's really very important because, as I said, in practice, we talk about much longer periods of time. In this one study about this ritual sexual abuse, those self-defined victims, they talk about like something 370 sessions of therapy, 370. That's quite a lot of time. And maybe, of course, not all the time suggestion has taken place, but as you can see, what you can do within 3 sessions with some expectation of there must have been something, then you can imagine what 370 sessions might result in. Okay, let's start with false memories and let's go to decision making. Quite a lot maybe, but I trust you. You remember your questions later on. As I said, legal decisions are made by humans. And as I said, I would like to start to present one case of bias in decision making, which is kind of inherent in some types of legal judgments, namely negligence judgments. I don't know whether you've heard of hindsight bias before. Maybe you have. I think this picture really exemplifies it very well. Because obviously, looking at that, you think like, maybe not such a good idea, whatever he did there. But that's, of course, looking now at it. While this person obviously had some good reasons for trying whatever he tried to do. And that's basically describing hindsight bias, which denotes the phenomenon that our hindsight perspective, so after some event has taken place, after some outcome we know now, is a different one than the foresight perspective before we know what event happens and or what outcome is taking place. Namely, after the fact, we have increased perceptions of inevitability. So we kind of have the feeling it had to be that way, or was kind of inevitable that it would develop that way, or that this outcome would take place, or whatever. We also have the increased perception of foreseeability. So we think we knew that all along. Wasn't that clear, like to everyone, or at least all the smart people like me. And so basically, the difficulty is here that those do not only differ, but people have a really hard time to try to get into this foresight perspective again, even when they're asked for it. So even if they are instructed to really just ignore what you know about the outcome, ignore it, and please judge the foreseeability from the foresight perspective, people are not really able to do so, or they are not really well in doing so. One of the reasons for this hindsight bias, there are different models, but maybe the one that's most important for the research here is that people try to understand what happens in the world. And so if some event, particularly if negative events take place, they are looking for some kind of explanation. So how did this, why did this happen? How did this happen? And so they are looking backwards on potential antecedents for this event. And what they're looking at are antecedents that are consistent with what happened. What they're not considering or what they're underweighing are antecedents which would have spoken for a different outcome. So basically they kind of ignore them, and then in hindsight it looks like, yeah, I mean, they all spoke for this event, all spoke for that this outcome would take place. I think this picture kind of nicely illustrates it. For instance, if I ask you, what do you think like about the US election right now? You would think like, it's uncertain. maybe it's like going this direction, maybe Trump is winning, maybe Harris. So and you kind of feel the uncertainty. I guess once the election has taken place, once we know the outcome, later on, you look back, you will have the feeling much more that it was kind of inevitable that it would have to be this outcome, or it was kind of much more foreseeable. So more foreseeable or more inevitable, at least, than in foresight, right? This is a problem, however, for legal decisions, because they always take place, at least in criminal law, after an event, a damage, or whatever has taken place. And this is particularly important for legal decisions about negligence, because in this question, you have to take this foresight perspective into account when judging whether another person was negligent because she could actually, or he could actually have foreseen that this damage would occur and should have prevented it or whatever. But if people are not if people are not able to really take this foresight perspective, then we run risk of unfair judgments. There were quite a few studies, there are quite a lot of studies on hindsight bias, but quite a few studies only on hindsight bias in judges. And so judges and law people usually kind of smile on the student studies and say something like, yeah, but we have legal training. So we're kind of, that's not an issue for us. And there were just a few studies on judges, and they had inconsistent findings. So what we did was another study, and we took an actual case, applied it to this experiment, and basically the idea was there's a prisoner from a correctional facility who was granted leave. There was quite a positive development in the past, has a new partner, wants to go on leave, meet the partner, etc. Does so, is granted leave, but then there's a discussion, there's an argument between the partner and the person, and they really, and he runs away. And I think in order to get something to eat or just money, he murders 2 women. And later the doctors were tried for the question whether they made a negligent decision, because the question wasn't at all along foreseeable that this would go wrong, and shouldn't you have seen the risk, and shouldn't you have prevented that? And so we took this case, and what we did was an experiment with 84 judges. And the one group was the foresight condition, where we just really gave them the case information until, okay, leave is granted. And then we presented them with 4 different outcomes and asked them to judge the foreseeability. One of them was the actual outcome, so that he murdered like 2 women. And I think there was something else. And we asked them also to evaluate negligence for the 2 negative outcomes we had. So in order to not suggest which one took place, we made use of 2 different negative outcomes. In the hindsight group, there were just 2 differences. So they got outcome information, obviously. So we told them, yeah, so on the leave, this happened and he ran away, and so later on murdered 2 women. And of course, but this is really what judges have to do in court, is that we ask them to evaluate the ex ante foreseeability. So basically, of course, at the time of that the doctors had to make the decision, right? So in the foresight perspective, where they did not know the outcome, so they had to ignore it. And what we find is a significant difference. And as you can see in the hindsight condition, there are more than twice as many judges who affirmed negligence than in the foresight condition, even though they all had training, they all had legal training, they were all sitting judges. So they exactly knew what ex ante judgment would mean. And some more analyses kind of tended to show, I wouldn't overinterpret this, but kind of gives the idea that outcome knowledge led to increased perception of foreseeability of that outcome. So knowing what happened, they had the feeling that there was foreseeable and that the doctors should have foreseen that as well. And this perception of foreseeability, this increased perception, led to more often to negligence judgments. Okay, so as we can see here, the ex ante judgment, which should be equal to foresight judgments, were not equal to foresight judgments. despite substantial legal training. There are quite some reasons why experience might not really make such a difference here, or the training, because people actually never get feedback, right? You never know for a case whether this was now hindsight bias or not. You never get corrected. You never get some kind of accuracy information. So how could you ever learn from that? But in those cases, experience doesn't really likely make so much difference, right? Because, I mean, you're judging every day, but you just don't know whether you're correct in judging. And so basically, there's good reason for why maybe this legal training or even experience does not really lead to an elimination of hindsight bias.
Is there no difference between the judges and lay people? There could also
a bit smaller. It's a bit smaller, but there's not so many.
Legal training helps.
Well, there's not a real comparison, but there's hints towards that it's smaller, but it's not eliminated. Yes, yeah, but let's still hope it does something. So, but still, we have a systematic risk of unfair judgments, right? And the prevalent problem, just as a brief outlook, I will not delve into this, is that in very different other cases as well, we only get information in hindsight. For instance, and I'm sorry, this is in German, but I didn't find like really better examples. In terrorist attacks, we often afterwards read something like, oh, we actually knew about this person before, or the federal agencies knew about this person and he was already on radar and like considered dangerous and whatever. But this is also, remember the figure I showed you explaining hindsight bias, this is also by trend one-sided, because we have some terrorist attack and then we're looking back for some reasons that might explain this terrorist attack. And what we, for instance, ignore are that, also in German, sorry, that more than 600 people, for instance, this is a number from 2023, are considered dangerous from the federal agency. But obviously not all of those 600 people, go ahead and do a terrorist attack. So how do we ever, really could identify those who do? It's not that easy, but it's very easy to, in hindsight, kind of have the impression or give the impression or suggest that it was clear all along. And if you would have really made a good job, then you would have seen that as people in hindsight see it. But that's maybe just an error in judgment, right? This perspective from hindsight. Okay, let's stop with hindsight bias and let's go to this last topic I'm going to present. It's about pre-trial publicity. And let's just dive into it. So when it comes about to news about crimes, there's a tension between fundamental rights, right? On the one hand, we have this fundamental freedom of the press. And I'm presenting here German as well as US American references because it's actually a study with US data. And on the other hand, you have the right to a fair trial. What was developed to, deal with this tension is that various guidelines have been issued that specify, like, for instance, the types of information that threaten a fair trial or restrain actors of the legal process in their comments and so on. Despite this code of conduct, however, we know that quite a lot of media reports are problematic. Studies range between like 27 and 68%. And pre-trial publicity is very often exaggerated and biased. Biased meaning that it's mostly anti-defendant, so against the accused one, against the suspect, against the defendant, partly even violating presumptions of innocence. In a very extreme case, one can even speak of a trial by media, so where basically a person is already tried in the public, more or less, and judgments about, guilt and innocence are made in the public. There's also, like on every other topic, there's quite some research, so much research that there have been already 2 meta-analyses. And they show clearly effects in terms of exposure to negative, meaning anti-defendant pre-trial publicity increases guilty verdict preferences, and exposure to positive, much more rarely, but positive pro-defendant pre-trial publicity decreases guilty verdict preferences. However, none of these studies, so it's more than 50 studies or whatever, actually analyzed actual legal judgments. So it's always, for instance, like in the meta-analysis by Stabley and colleagues, they kind of summarized what types of studies those were. It's either a survey where people are called and asked about an actual case, and whether they kind of, follow the media. And so they have to kind of judge like how much they follow the media. And then they have to kind of judge like how guilty they see the person who is tried. Or simulation means here like experiments, the classic experiments where people get different kinds of pre-trial publicity. So news articles, then the same case. And then you can look at whether this pre-trial publicity affects the guilty verdicts. Sorry. And those other numbers, we coded that for the later meta-analysis as well. And as you can see here, so it's always people making judgments that don't matter. Don't matter in terms of course, public opinion, yes, but not in terms of actual legal consequences. Because never ever is someone asked who really has to take the consequences, has to bear the responsibility of his or her own judgment. But that, of course, can make quite a difference. And this fact that the pre-trial publicity is based on like simulations and surveys led judges to dismiss scientific evidence regarding pre-trial publicity. For instance, in the Oklahoma City bombing trial of Timothy McVeigh, you might remember, Judge Match, I don't know, discredited the research consisting largely of simulated trials and rather trusted his personal experience as a lawyer and judge. And in another study where judges were surveyed, they also found quite a lot of trust in jurors' abilities to feel, and the feeling that the concern over news coverage tends to be exaggerated. So basically, there's a lot of research, but like the judges say, yeah, but it's not really relevant for us because it's just, it's just too far away from from real life. It has also led researchers to criticize the lacking ecological validity. And there's one exception. One exception that was a field study, which is not in those meta-analyses, where Bruschke and Loges, I don't know how you pronounce them, analyzed first-degree murder cases, federal first-degree murder cases, and extracted the number of articles covering those cases with that defendant from a database, LexisNexis. And the pity is, however, that they really dichotomize and categorize variables really arbitrarily, and the findings are inconsistent. For instance, they split cases into sentences below 500 months and above 500 months. And so you wonder kind of, okay, but how would the results differ if you would have taken another approach? You don't know. And we know that it's nevertheless better to just not dichotomize or categorize variables. So basically what we wanted to do is to kind of replicate and extend this study because we found it really neat, but we found it rather, unsatisfying to see those results where you did not really know what to make of it. So we went as well to different databases, the Federal Court Cases Integrated Database in the US. It's all publicly available data. It's just difficult to really get them and merge them. And what is here on one slide is really years of work. So it does look like it, but it's really, really effortful. We identified 420 federal first-degree murder cases, so they're comparable because, of course, the states have like different laws, which were tried between 1996 and 2022. Excluding cases of guilty pleas or plea agreements, because we really wanted only to include cases where a jury made a decision and a judge, made a decision about the sentence. We extracted sentence and also severity indices, important for later. Then we went to another database to get the defendant names, and then we went to yet another database to get the pre-trial publicity on those cases. And after a really extensive article screening process, we ended up with 4,401 articles, which were related to about roughly half of the samples, so 200 and something, and 200 and something cases were without pre-trial publicity that we identified. The study was pre-registered, so we pre-registered analyses and hypotheses. And the first question was, is there a link between pre-trial publicity level, meaning the number of articles per case, per defendant and the sentence. And as you can see here, the correlation says, yes, there is. As you can see here also, it's not really steep. So it's not really a large effect, but there is an effect. And to give you an idea of the magnitude of this effect, nevertheless, I contrasted cases with and without pre-trial publicity. So basically, here's still the sentence. Oh, it's months. Sorry, it's months. So how many months they have to spend in prison. And as you can see here, so no pre-trial publicity ends up with more than 10 years less of prison time compared to cases with pre-trial publicity. And consider that it's all first-degree murder cases. So we're not talking about like murder here and theft here or whatever. So it's already within a quite homogeneous sample of types of crimes. There's still variability, but likely not very much. Still, correlation means just, okay, they're connected. That doesn't mean that the one causes the other one, right? We don't know. What we just can do is try to rule out some alternative hypotheses. And some we had was, for instance, regarding severity. We thought, okay, more severe crimes likely get more press, but of course also likely get higher sentences. If this is the case and severity, like as a third variable, affects the other two, then it's just logical that there's a link between those other two, right? And as you can see here, yes, severity is linked to those other two variables, as is kind of similar number of victims and children as victims. But if you control for those third variables, control means you kind of try to calculate that influence out, right? So in terms of you try to take the impact of severity out, then it's still the case that we find a significant link between pre-trial publicity and sentence. So those third variables do not explain this link between publicity level and sentence, okay? As you can see here, sometimes it goes down, but it's not, you know, it's not non-significant afterwards. Another question was, is pre-trial publicity mainly anti-defendant, as prior research has shown? And we did a content analysis. We had people code, also very effortful. Let's not dive into the details. And what you can see here is we had two variables, which I'm presenting here is they had to judge the articles with regard to whether they are strongly pro-defendant or strongly anti-defendant, and whether they present the defendant as very innocent or very guilty on a 5-point scale each. And as you can see here, so the distributions are really very skewed to the right, which means many more articles were anti-defendant and presenting the defendant as guilty. And this also, at least the article stands. So the case that an article is anti-defendant also is linked to sample. As you can see here again, it's not really a large effect. And for guilt presentation, we do not find a correlation, but there is still some link between the more negative the pre-trial publicity, the higher the sentence also, right? Okay, last two slides. We find here that pre-trial publicity robustly predicts sentences. Again, predicting is not meaning causing, we don't know. But at least for those third variables we could think of, but we're not law people, so maybe you want to add another third variable here. It was not explained by severity or number of victims or child victims. If you have ideas for further potentially relevant third variables, please let me know, because if we have any data on that, I would like to check that out too. But so far, I would kind of conclude that our research is complementing the experimental and survey findings with regard to actual sentences. So adding to the previous research, which has shown causal effects in experiments, we are now adding the actual decision, the link to actual sentences. As we have found, pre-trial publicity content is mainly anti-defendant, which is already kind of suggested by the link between level, number of articles, and sentence. And it might be important to know that in our sample, we only had serious newspapers. So it was not covering yellow press. We did not dive into social media or whatever. That would be interesting too, but it's just so effortful. So yes, maybe someday later, but that was already really a pain. Well, and interestingly, it's not so much about presenting the defendant as guilty, that was linked to sentence, but rather presenting the defendant negatively in general, that was linked to higher sentences. We still have something to do, automatic text analyses, and we want to look into the demographic variables of the defendants, but we don't have them yet. Okay, let me finish with some conclusions and implications before I end this talk. In general, I would say eyewitness evidence must be carefully assessed if it's really central to the case. So if the case actually rests only on eyewitness evidence, and of course there's rulings from the Bundesgerichtshof, etc., then it might be needed that an expert takes a look at it, so that we have an expert assessment, because it's really, as I tried to show you, it's really not easy, for instance, to identify false memories. Laypeople and judges have difficulties to ignore outcome knowledge, also to ignore other knowledge, by the way, inadmissible evidence, for instance. Just ignore this. It's really difficult. Also for experts, but particularly for laypeople. One countermeasure, particularly for hindsight bias, could be the consider the opposite technique, which means that you try to come up with counter arguments against your own thoughts, against your own beliefs, against your own convictions. You really try to deliberately think, okay, what would have spoken against it? That way you try to, break up this one-sided information processing from looking back, and you try to better be aware of those antecedents, for instance, which would have spoken against this one. And research shows that this is effective in at least reducing hindsight bias, maybe not eliminating it. If possible, expert assessments should be done without outcome knowledge. I know this is difficult, but I have become aware of cases, for instance, medical cases, where, I don't know, some general doctor was accused of negligence because of not diagnosing some kind of, what was this, thrombose? What is it in English? Thrombosis, I don't know. And then an expert was about to assess whether he should have foreseen that. The expert, however, was an expert in thrombosis. And that's, of course, a totally different perspective. So maybe, yes, that person could have known that, but that's really just totally different from the foresight perspective of that general doctor. Okay, and last, pretrial publicity is mainly anti-defendant, as we can see, and thus endangers a fair trial. And I think this combination of a field study and experimental evidence suggests that judges should take potential pretrial publicity effects into account and not just dismiss and discredit them as they have done in the past. Thank you.